There's been a lot of bad, false information in the media coverage of the Derek Chauvin trial, both factually and legally. I wanted to make this video to correct one of the false legal assertions that I've seen made about specifically the third degree murder charge against Derek Chauvin and what the legal requirements are or aren't of that third degree murder charge. I've seen it made specifically by Ben Shapiro. I'm sure he's not the only one to have this false impression of what the law is, but I've seen him make it. He has a large audience, and it's bad information. It's wrong, so it needs to be corrected. I want to be clear that I don't think that this is, Ben intentionally misrepresenting what the law is. This is not supposed to be a hit on him or a slam piece, but he's spreading bad information, and so it needs to be corrected. So again, it's the third degree murder charge that I'm talking about here. Here I'm showing you the criminal complaint, which is a document filed in every criminal case to just put the defendant on notice of what the charges are against him. You can see here we have, up at the top, State of Minnesota versus Derek Chauvin. There's 3 counts, 1, 2, and 3. And this second one, there's a second degree murder one, a third degree murder, and a second degree manslaughter. But it's this third degree murder charge that we're interested in for purposes of this video. It tells you the statute here, 609-195A, is the statute he's alleged with violating. So let's take a quick look at that. So here's that statute, third degree murder statute in Minnesota. All of this stuff is available online. And remember that the complaint said subsection A. So this is the portion that they're charging him with violating. You can read it if you want. You can pause it and read it. I'm just going to keep going. Let's take a quick look at what Ben Shapiro has said about this murder charge.
Okay, now we get to the actual Derek Chauvin trial. Okay, so again, it's all the narrative surrounding the trial that the media are very into. It's not the actual facts of the trial that matter. In reality, it is very, very difficult to achieve a confession beyond, to achieve a conviction beyond a reasonable doubt in this particular case. The nature of the charges makes it very difficult. Okay, the reason that makes it very difficult is because there are several charges that have been brought against Chauvin. We've explained this on the program before. There's third degree. Third degree murder does not really apply in this case. Third degree murder is a case where you are threatening murder it's what's called depraved heart murder, where you don't care that somebody is going to die, but it has to be directed at a random victim. Okay, it can't be that you targeted X and you didn't care about X and that person died. It has to be like you take a brick and you throw it off of the top of a freeway intersection, off of an overhang, and then you hit a car, right? That would be depraved heart murder. You don't care who it is you kill. You're targeting just kind of generally humanity at large. You shoot a gun into a crowd, right? That would be depraved heart murder. So third degree really does not apply in this case. It doesn't fulfill the elements. He has been charged with second degree murder, or Derek Chauvin has been charged with second degree murder, third degree manslaughter. Those are the 3 crimes with which Chauvin has been charged. Third degree murder doesn't even apply. Third degree murder is what's called depraved heart murder. As I've suggested many times, depraved heart murder is a crime where you shoot a gun into a crowd. And we can't convict you of specific intent to kill Bob, but Bob was one of the members of the crowd, so we convict you instead of depraved heart murder because he didn't care who died. You just knew somebody was likely to die when you shot a gun into the crowd. That doesn't apply here because Chauvin didn't neck suppress 100 people and one of them died. That's not the way this worked.
So you can see Ben here making the argument that third degree murder doesn't apply to the Chauvin case because Chauvin's actions were directed specifically at George Floyd, and that Ben says third degree murder should only apply when you act with regards to a crowd and one person happens to get hit, but you weren't acting towards that person specifically. That's wrong. That is just flat out wrong as a matter of what the Minnesota law binding this case is. Now, I want to emphasize again here that it's actually very reasonable. By reasonable, I mean understandable why Ben thinks this way. When you go to law school, you don't learn all the different legalities of each different state. And oftentimes, you don't even learn really the specifics of the legal statutes in the state that you're in law school in. You tend to learn more legal theory. And so it's not surprising that Ben doesn't understand this point about Minnesota law, a state that I don't think he's ever lived in or worked in or studied in. In fact, it would be quite impressive if he had gotten it right, except for the fact that he is holding himself out as a commentator on this, and I'm sure he has a team. So, again, this is just bad information that needs to be corrected, but this is not supposed to be a particular hit on Ben. But let's go through and let's look at why I can say so definitively that he's wrong on this point. So the reason that we can definitively say that Ben is wrong in his analysis of third degree murder here is that this is a question that has been directly confronted and answered by the Minnesota Court of Appeals in a recent case that is binding on the Chauvin trial. So let's take a look at that case here. It's the Noor case, state of Minnesota versus Muhammad Noor. This is actually kind of a famous case in its own right, independent of the Chauvin trial. But we're just going to talk about it here with regards to what it said about third-degree murder. I'm going to scroll down, and you can see I've just highlighted some of the key passages here, and I'll read them out. So this is the Court of Appeals opinion, meaning this is the Court of Appeals ruling on the Noor case, but this will be binding law on the Chauvin trial. So I read, and the third-degree murder statute's reference to perpetration of an act eminently dangerous to others does not preclude its application when the death-causing act endangered only one person, because in construing statutes, the singular includes the plural, and the plural includes the singular. As explained by one leading legal scholar, convictions of depraved heart, murder can be based on conduct endangering a group of persons or only a single person. And then down here, because Minnesota Statute 609-195A, which is the statute we looked at earlier, the third-degree murder statute that Chauvin's being charged under, because that statute does not require that more than one person be put in jeopardy, and the Supreme Court in this other case upheld a conviction of third-degree murder, even though the victims were known to and targeted by the defendant, we cannot say that Noor's third-degree murder conviction is invalid simply because his dangerous act was directed at the single person outside of his partner's window. And then I think one more here to read. We therefore hold that a conviction for third-degree murder under Minnesota Statute 609-195A, again, that's the statute that Chauvin is charged under, may be sustained even if the death-causing act was directed at a single person. And then finally, if we scroll all the way down, I'm skipping, there's a lot to read here. I'm just kind of skipping, just trying to give you the punchiest highlights to prove my point. But if we skip down, decision. This is the very end of the court's opinion, right? The evidence at trial was sufficient to establish beyond a reasonable doubt that Noor committed third-degree murder under MinStat 609-195A, even though his death-causing act was directed at a single person and the result of a split-second decision. So this opinion by the Court of Appeals in Minnesota definitively shows that third-degree murder statute can apply even where the defendant's actions are targeted at a single person. Now, I'm going to go a little bit into, I could just stop there, right? That's basically enough to show that Ben is wrong. I'm going to go a little more into the procedure of the Chauvin trial because, honestly, partially just because I think it's interesting, and it was actually a very important part of the pretrial procedure in this case. But it'll also give a little more context to kind of what we're talking about here, and it'll further demonstrate that, in fact, Ben is wrong when he says that third-degree murder can't apply to the Chauvin trial. So what happened in the pretrial for the Chauvin case is that the defense and the prosecution of the defense basically argued about whether the third-degree murder charge could be in, and the argument pertained around this issue of whether or not third-degree murder could include behavior or could cover behavior that was directed at one individual. Now, this is all occurring after the Noor case. So you might be asking, well, if the Noor case definitively said, ruled on this and said that it could cover behavior directed at one individual, why were they arguing about it? And really, it was a matter of timing. So they disagreed as to whether that Noor case had become binding yet. They agreed that if it was binding, it would say that third-degree murder could charge or could cover behavior directed at one individual, but they disagreed about the timing. So what I'm showing you here is the district court's order basically not letting the prosecution reinstate the third-degree murder charge. And in their opinion, where they explain their reasoning, this is the district court's words here. This is their opinion. They say the state is correct, the state being the prosecution, that if the Court of Appeals published Court of Appeals Noor case is precedential, this court, meaning the district court, is now duty-bound to follow it and grant the state's motion to reinstate the murder charge in the third degree. But the district court says, however, the Noor opinion, while published and labeled as precedential, does not become final and have precedential effect until the deadline for granting review by the Minnesota Supreme Court has expired. So what the district court is saying there is, yes, there's this Minnesota Court of Appeals opinion, the Noor case, that should at some point become binding on me, but it hasn't yet. And at the feeling that it wasn't bound by this Minnesota Court of Appeals decision, the district court exercised its own discretion to decide what it thought the law was, and it came down on the side of the defense, which argued the same thing that kind of Ben Shapiro is espousing, which is that third-degree murder cannot apply to behavior directed at one individual. And so the district court at that time kept the third-degree murder charge out. So why is it still in? Well, because this issue, before the trial started, then went to the Court of Appeals. So here's that Court of Appeals decision. Again, all of this occurred before the trial started. This all occurred kind of back around February 2021. And the Court of Appeals took up this issue of, hey, is the Noor case binding on the district court at this time, or is the district court right that the Noor case is not yet binding? And the Court of Appeals, I think I have it highlighted here. Here's one part where they said it. In conclusion, we discern no valid authority supporting Chauvin's argument that a precedential opinion of this court is not binding authority so long as further review is possible or pending. So they're rejecting the argument that the Noor case is not yet binding. They're saying it is binding. We therefore hold that a precedential opinion of this court is binding authority for this court and district courts immediately upon its filing. So they're saying the second we decided that Noor case, it became binding on all district courts. And so they sent this issue back to the district court, and the district court ended up putting the third degree murder charge back in. We now know that the Noor case is binding, and the Noor case tells us that a third degree murder charge does not fail in Minnesota just because it's regarding behavior directed at one single individual person. So hopefully that wasn't way too much detail. I wanted to not only show why we can be confident that what Ben was saying about third degree murder was wrong, but also show a little bit about kind of how this stuff works, how complicated it can be. You know, our legal system is not easy to grasp, even for lawyers, right? Even for people who went to law school, it's not easy to grasp. And unless you're paying really, really close attention, it's very easy, in fact, probably likely, that you'll have some serious misconceptions about what happened or why it happened or what the law is. And it's very bad to have people walking around confident in misinformation. I mean, I probably don't need to tell anybody this, but having people believe strongly things that aren't true leads to bad outcomes. So, hopefully Ben corrects this on his show. I hope he sees this and then on his show, issues a correction, because it's really bad if there are millions of people out there who think that third degree murder only applies or can't apply to Chauvin because his behavior was directed at one specific person. Because now what happens is, say Chauvin does get convicted of third degree murder, which is probably the best. I mean, I don't want to get too much into this, but one of the reasons I was following it so closely pre-trial was that this was the charge that I thought it was going to be the most likely one to stick. I think the other two charges have some pretty significant issues with them that make them not easy to prove. And, Ben was talking about that, and to give him credit where it's due, I think he was right about a lot of his points. But if Chauvin now gets convicted of third degree murder, and there's a lot of people who think, hey, how could that be? That charge only applies when you act towards a crowd and not towards one specific person. Well, now those people are going to be in this state of friction between what they believe and what reality is, and they're going to come up with explanations for why it happened. So they might think, oh, the jury must have just hated cops so much that they, that they convicted him anyways, even though legally they weren't supposed to. Or, maybe the city rigged it against him because they needed to scapegoat somebody. Or whatever the case may be. It's bad to have wrong information, and it's bad to be confident in wrong information. Okay. I'll stop the video there. I can feel myself starting to ramble, starting to get on my soapbox. Ben, I hope you see this, and I hope you issue a correction on your show. Other than that, if you like this video, let me know. Leave a comment if you have any questions, and I'll see you guys in the next video.